If you have been on social media lately, 9 times out of 10, you have heard somebody go on there saying that wills are trash. You need to make sure you get a trust. You need to make sure you protect your assets and take advantage of these tax benefits by creating a trust. And I do want to say that I am one who very strongly advocates for people creating a trust as a part of their estate planning. Although I do recognize that it's not a one size fits all solution, and a trust may not be the perfect thing for everybody. But we're not talking about which one you need to get, a will or a trust. What I want to talk about today is making sure that if you do get a will, that you include some very important provisions in your will to make sure that you are making things as easy as possible for your family. So a lot of times with these videos where they're saying you need to make sure you get a trust, you want to make sure you don't have a will because a will is going to slow everything down. There is some merit to that. When you have a will, it is designed to go through the probate process. So that means you have to draft the petition and file the petition along with the will in the probate court. Then you have to wait for all of the heirs and the beneficiaries of the will to be notified, and then have the court appoint you as the executor of the estate. That process can take some time. However, if you don't have these four provisions in your will, then you definitely are going to be in there for a longer period of time than you probably would want to be. There's going to be more time taken to allow you to be appointed as the executor of the estate. And there are some additional requirements that you'll have to meet that if you have these four important provisions in your will, you will not have to meet those requirements. I do want to say that if you are in the state of Georgia, this information will be most helpful to you. It may not be as helpful for those who don't live in the state of Georgia, although it could be very helpful. You just want to make sure that you check with someone who's familiar with the laws of your state, because I'm approaching this from the standpoint of a Georgia lawyer. So, state law says that if a person dies with a will, then their executor or their personal representative is going to be responsible for one, getting a bond to protect the value of any personal property or cash that this person may have, that the executor may have in their possession when they are handling the estate of the person whose will they're handling. So they might have to get a bond. They might have to report to the court to provide an inventory. These are the things that in the estate, these are the things that are in my control, so that the court is aware, and that so that the heirs and beneficiaries are also aware of what items are in the estate. Well, mainly it's mainly going to be beneficiaries, but I digress. I'm going into the weeds a little bit. So you want to make sure that the state law is going to require that an inventory is made of all of the property that's in the estate. Um, you're also going to have to do annual reports to the court, making sure that the court is advised of how you're managing the estate, what money is coming in, what money is going out, what property is coming in, what property is going out. And you will have to provide annual statements to the heirs and beneficiaries. And I might be a little sloppy in my language here, but the people who are interested in the estate, you will need to provide annual statements to them to let them know, hey, this is the money that I've been managing on your behalf. This is the property I've been managing on your behalf. And those things can take extra time, extra resources. If you have to file something with the court, you have to pay a filing fee every time. You have to notify, you have to send a copy of everybody who's entitled to notice. You have to send those to them in the mail. So all of those things can add add cost to the estate. It can add time and just a lot of extra work for the executor of the estate if you are going according to state law, which says that you have to do these things. If a person has a will that waives those requirements, then the executor more than likely is not going to have to meet those requirements. And I say more than likely because there might be some circumstances where the court might still require it, even though the will does not. For example, if someone contests the will and they say, I don't trust that executor, I don't care if my mama named her over her estate, I still don't trust her, and I want the court to still hold her accountable. In some cases, the court might say, you make a good point. We're going to still require them to get a bond or require that they get an inventory, well, file an inventory or file annual returns, or even just give statements to the heirs and or beneficiaries. Excuse me. So that might be a case where the court would go contrary to the will, but in most cases, if there are no weird circumstances or anything that would compel the court to do otherwise, the court is going to follow the will when it comes to whether or not the executor has to have a bond, whether or not the executor has to file an inventory, whether or not they have to file annual returns, and then whether or not they have to file statements or present statements to the heirs um, and beneficiaries. And I'm saying heirs and beneficiaries. I'm gonna just be honest with you. I need to check the statute to see if, in the event of having a will, whether or not we have to serve notice on the heirs and beneficiaries with all of these things. I have to kind of check because every case is so different, and you kind of get focused on that case, and then you think, well, what about this other circumstance? So I'm just being honest with y'all, telling y'all I got to double check the statute on this. So we're gonna say heirs and or beneficiaries, so we cover all bases. Remember, and I didn't tell y'all this at the beginning, but when y'all look at my videos, I'm not telling you what to do in your case. I'm just giving you some scenarios, things to think about. I always encourage you to hire a lawyer to know for sure what to do, because I'm talking off the top of my head. I'm trying to make sure I'm saying things exactly how the law says, but ultimately, you need to hire a lawyer to talk with you about your own personal circumstances and how the law applies or does not apply to your own situation. So I did my little lawyer thing, gave my disclaimers and things like that. But what I will say again, just to make sure I'm clear, that there are certain requirements that state law will put on someone who's serving as the executor of a person's estate. However, if the person whose will is being admitted, going through the probate court process, if the person's will waives those requirements, then the executor does not have to meet those requirements, even though state law puts them in place. Because the will can waive some requirements of state law. That's why it's so important to have a will, if nothing else, so that you can set the ground rules for how your estate is going to be handled by your personal representative. Another thing that your will can do is waive the requirement of getting the court's permission to sell property from the estate. So, can you imagine how much easier it would be if you have a house that is part of the estate? The executor wants to sell the house, and I use the word executor, personal representative interchangeably because they can mean the same thing. Personal representative is the broader term that applies for estates when there is a will or without a will. Executor only applies to situation where you have a will, and this is the person who's over the estate of someone who had a will. So again, another little legal disclaimer insertion there. But what I was wanting to say is that if the will if the will waives the requirement of having to have court supervision for the sale of property, that's going to be an extra step that your executor or your personal representative has to take before they have the legal authority to sell property from the estate. So imagine, and I get this a lot, realtors come to me and say, hey, we have a closing scheduled in a week, and we realized that after the closing attorney ran the title, we realized that the seller actually didn't have legal authority to sell a property. It's still in the estate of their deceased loved one. Can you help us to get this ready for closing next week? Most of the time, the answer is no. However, I will say I can imagine a situation where if someone had a will that gave the executor the power to sell the property, we might be able to get the court to go ahead and grant them letters testamentary, giving them authority over the property. Then they can quickly be ready for the sale of that property for the closing in that following week. However, if that will does not waive the requirement of selling the property, if it does not waive the requirement of filing an inventory, getting a bond, doing those annual returns, or whatever the case may be, if the will does not waive those requirements, it's going to slow that process down. The court is not going to be as inclined to quickly give letters testamentary to the executor. They're going to say, hey, wait, we actually have to run this in a newspaper for a period of time, or we're going to issue you some letters testamentary, but they're going to say you don't have the power to sell, or they're going to say you are required to file an inventory, or you're required to file returns. And so I've had this happen many times where someone will come to me, their loved one has died, they have a will, and they say, "Hey, Veronica, can you help me to be the executor of my loved one's estate?" And I'm excited. We got a will, we get it filed with the court, and then we realize in the process that the excuse me, the testator did not waive the requirement of selling the property, or in the will, the testator, and I say testator, that's the person who created the will, and now they're deceased. So we will find that they didn't waive that right, the requirement to sell. They didn't waive the requirement of a bond. They did not waive the requirement of an inventory or annual returns. Something like that often has been left out. And so now I'm very intentional to make sure when I do my wills that we include all of that. But a lot of times wills don't include those things. And so the executor still has to go through certain court processes and check certain things off the list before they get full authority over the estate, or they just have those things along the way. So a common situation I have, we have the executor of an estate, they have letters testamentary, they're able to um, do everything they need to do for their loved one's estate. However, 6 months after they become the executor, they now have to file an inventory with the court, and they have to say these are all the assets in the estate, and they have to provide a copy of that inventory to the court, give the court the original, and give a copy to all of the beneficiaries of the will. Again, I gotta check that, but I think it's just the beneficiaries. Once the executor is appointed, I think the heirs, if they're not also beneficiaries, they're not required to, they're not entitled to get any more notice. It's just the beneficiaries who are listed in the will who are entitled to notice. So you have to serve all of those people with a copy of the inventory. Or you might have another situation where the executor's will did not the executor's will, the testator's will did not waive the requirement of getting a bond. So let's say that you have $100,000 in assets in the estate. You might have to get a bond to cover those assets, depending on what types of assets they are. Or the testator may not have waived the requirement of filing annual returns. So then that means that if the estate is open more than a year, you're going to have to file a report with the court. This is what I've done with the estate. Or even if you get it done in less than a year, you still have to file a final return showing the court this is everything I took in and this is everything that has gone out. The will can waive those things, but you have to make very certain that you specifically put wording in the will to state that that's what you want to happen. So, this message is for people who are still living, of course, and have not done their estate planning, or they know it's time for them to do a new estate plan. And they're thinking, I would like to have a will as part of my estate plan. I want to make sure you know that you need to make sure that these special provisions are included in your will so that you can make things easier for your loved ones. I will say on the flip side, some people want a little bit of hurdles in there. They want a little friction. They don't want to make it too easy. They want some accountability. So they might say, you can't sell property from my estate unless you get additional permission from the court. Or they might say, you cannot um, handle this estate unless you let the court know what's in the estate. You provide an inventory, or I want you to provide annual reports to the court. Sometimes you do want to do that because not only you may not trust the person 100%, you might trust a 95%, but that other 5%, you're like, we need to put a little checks and balances in there. Or you might say, for the sake of protecting my loved one, I'm going to put these requirements in there so that nobody can accuse them of misusing it, the mishandling the estate. You might have those considerations as well. So I just wanted to throw those things out there to give you that tip when you are working with your estate planning attorney. If you're in Georgia, I would love for you to reach out to me. We would love to help you. But wherever you are, if you are working with your estate planning attorney and you want to take away those additional hurdles that can slow down the process or make the process a little more costly or a little bit more hassle for your personal representative slash executor. Then you might want to talk to your lawyer about waiving the bond requirement, waiving an inventory requirement, waiving the requirement of filing annual returns, and waiving the requirement of providing statements to the heirs. You may also want to ask them to put in that your executor has the power to sell property from the estate. Usually that's going to reference a statute here in Georgia that says that they have the power to sell, they have the power to lease, they have the power to do all kinds of things with any property in the estate so that they can more efficiently and more effectively handle the estate. So I just want to give you those tidbits, those 5 things that you want to make sure are included in your will if you want to make the estate administration process go more smoothly, have fewer hurdles for your loved ones after you're gone. Thank you so much for tuning in. This is attorney Veronica McClendon of McClendon Law and Consulting. Please like this video, share it with someone who might find it helpful, subscribe, and take action. If you know that you are ready to get your estate planning done, why don't you go into the description for this video, click the link, and schedule a legacy planning session, and we can start talking about how to get your estate plan in place so that you can have your family to have peace of mind and less friction in the estate administration process. Y'all have a great day, and I'll talk to you soon.